सब कुछ हम देते हैं, गूगल है वो तो मतलब मैं इसलिए ऑनलाइन पेमेंट का नहीं कर रहा ना, जैसे जैसे कुछ नहीं पता ऑनलाइन का मैं क्या दूंगा भाई, अगर तुम थोड़ा निकालते कहीं फंस गया तो उसको बता दो, कुछ भी नहीं आता तो जाके राजू बना दो, यहाँ से पेमेंट तो बात हो जाता है, तुमने मैं नहीं अगर आप चलाना नहीं जानते तो बहुत परेशान होता हूँ, गए वो पता लगे। ठीक है। Welcome to the next session of MMPC 13 Business Laws. In continuation of previous sessions, in which we covered up to unit number 3, that was the Partnership Act under Block 2. Today, we'll be exploring very interesting act, that is the Companies Act of 2013. In this particular unit, various dimensions that are interesting as well, and we are likely to go through them. How a company is formed. Exactly, first, what is a company, then how it is formed, then what are the principal documents that are required for a company, and what is a couple of documents like Memorandum of Association, that is MOA, Article of Association, that is AOA, prospectus, and components like shares, share capital, etc., company management, meeting, and ultimately in the concluding session, concluding part of this unit, there is a aspect that is how the company can be wind up. So company is ideally for perpetual existence, but there will be scenario when company may need to be wind up. So what are the procedures that will be explored in today's sessions? Well, basically, companies with unlimited liability, due to unlimited liability of partners of the traditional partnership under the Partnership Act, become a hurdle to meet the capital requirement. Well, from formation on its winding up, a company is governed by Companies Act. Apart from the Companies Act, other acts like Companies Secretaries Act, the Competition Act, Monopolies MRTP Act, the Indian Partnership Act, SIC Industries Act also have some control in changing corporate world. Well, the Companies Act of 1956, preceded by Companies Act 2013, and this Act of 2013 contains 29 chapters, which having 470 sections and 7 schedules. As I mentioned in previous session, there is some limitation in the form of partnership form. To overcome that, there was a concept that was introduced way back in 2008 in the form of an LLP, limited liability partnership. Well, which is something scenario in between the company and the partnership, right? The partnership. So LLP is something in between. So company involves a lot of a little bit more complications. So let's explore how this Company Act is applicable. Well, companies incorporated under this act or under previous company law, insurance companies, banking companies, companies engaged in generation or supply of electricity, any other company governed by any special act for the time being in force, and such body corporates which are incorporated by any act for time being in force, and as the central government will be by notification is specified in this behalf, are covered under Companies Act. Well, a company can be formed. Basically, a company means a company incorporated under this act or under any previous law. Well, Section 2, subsection 20 of the Companies Act 2030 gives this definition, but this definition doesn't give a very clear meaning. So the actuate may be a corporation is an artificial being, invisible, intangible, existing only in contemplation of law. As per Henning, a company is an incorporated association which is an artificial person created by law having a separate entity with a perpetual succession and a common seal. Well, the major features, the common features with reference to company is, we can say, well, it has got limited liability, it has got perpetual succession, but it has got separate legal entity, separate to the its board of directors or members. Well, it has got an incorporated association. It is an artificial person. It has got common seal, and it has got a feature of transferability of shares. Well, the companies may be, as per the classification of the term company is, it may be on the basis of liability, well, on the basis of members, on the basis of control. So on these three bases, company may be further divided. If it is basis on the liability, it may be of maybe three types, like a company limited by shares, company limited by guarantee, and unlimited company. Whereas on the basis of member, it may be OPC, one person company, that is called as OPC. Then private company, which is defined under section 2, subsection 68. Then small company, which is defined under section 2, subsection 85 of the Act. Well, it is other than public company. Then the public company, it is defined under section 2, subsection 71. Well, definitely public company is not a private company and has a minimum paid up share capital as may be prescribed. And the status of private company, which is subsidiary to public company, is also defined under section 2, subsection 71 of the Act. Well, then there are other forms of company. As I hope you can recall, I mentioned something of section 8 company in a previous session. So anything, any company or body corporate, so that is incorporated to promote a charitable objective of commerce, art, science, education, etc., is called as Section 8 company. So in addition to number or member or sort of thing, the other types of company include a government company, which is defined in Section 2, subsection 45, a foreign company, which is defined in Section 2, subsection 42, then Section 8 company, as I touch upon this particular topic, then there will be a dormant company. Well, it is defined under Section 45. It is very interesting one. Well, where a company is formed and registered under this Act for a future project or to hold an asset or intellectual property and has no significant accounting transaction, such company or an inactive company may make an application to the registrar in such manner as may be prescribed for obtaining a status of dormant company. Well, this helps in sort of tax regime sort of thing. So this is helpful to attain a status of dormant company, and whenever it start functioning back, it return back to normalcy. Then an inactive company. Well, inactive company is not carrying on any business or operation or has not made any significant accounting transaction during the last 2 financial years, or has not filed financial statements and annual returns during the last 2 financial years. Well, as far as next is Nidhi companies, so they are basically mutual benefit society, a company which the central government may, by notification in the official gazette, declare to be Nidhi or mutual benefit society, as the case may be, to lend and borrow money to the members for the purpose of their mutual benefits and to cultivate savings habits among members. These are classified as non-banking financial company (NBFC), and the last one type is the general financial institutions (PFI), and this is defined as Section 2, subsection 72 of the Act, which includes LIC, ID, FCI, specified company referred in this UTI, and institutions notified by the central government of India under Section 4A, subsection 2 of the Companies Act 1956, well, which was so repealed under the Section 465 of this Act. Well, other institution as may be notified by the central government in consultation with RBI. Well, an institution shall be so notified by as PFI if it has been established or constituted by or under any central or state act other than this act or previous companies law, or at least 51% of paid up share capital is held or controlled by central, state government, or partly by central, partly by one or more state government. Because the interesting aspect is it may be a combination of a central, combination of a state, it may be a combination of more than one or more than one states. Well, as far as the formation of companies concerned, it is a lengthy process, as we've gone through some aspects of formation of LLP in the previous unit. So similarly, it has got a series of steps. One is promotion. So a promoter may be an individual, firm, or an association of person or a body corporate. Well, then registration of incorporation, then commencement of business. So this is the basic aspects which can be explored in subsequent sections. Well, the principal documents of a company include memorandum of association, article of association, and prospectus. So memorandum of association is a charter of a company which lays down the objects of the company and also all the specific functions, operations, and limitations also. And the memorandum of a company shall be in respective forms specified in table A, B, C, D, E in the schedule 1. Well, then article of association, that is AOA, is a document that constitutes all the rules and regulation for the conduct of the internal management of the company. Schedule 1 of Act gives more four formats, that is format table F, G, H, I, and J. And then there is a prospectus. It is defined under section 2, subsection 70. So it gives us the variety of prospectus that are used in the company: red herring prospectus, then shelf prospectus, information memorandum, abridged prospectus, deemed prospectus, well, office for sale, offer for sale. So these prospectus have got their own limitation and their own dimensions. They have got certain information that may be desirable for the prospective investors, for the public to disclose. So, depending upon their type, they have a variety of information that is available, which is available for public to access, or as well as the competent authority who is authorized to access it is also accessible the same way. Well, share and loan capital. Well, we understand the requirement of a finance in any industry, any setup. So companies have got the feature that they can raise funds from the market, and that can be uh, or the capital that is required for a company may be of various terms that can be used for. One is nominal or authorized or registered capital, issued capital, subscribed capital, called up capital, paid up capital, uncalled capital, reserved share capital, and they are further defined specifically as well. Then, as far as the shares of the company is concerned, the share is a part of a percentage right sort of thing. So, if we call the types of share, they are of basically two types. One is equity share capital, and another is preference share capital. And the equity share capital has got voting rights, and they have got differential rights as to dividend, voting, or otherwise in accordance with the prescribed rules. Well, all share capital, which is not preference share capital, means equity share capital. Well, as far as the preference share capital is concerned, is that part of the issued share capital of the company, limited by shares, which carries or would carry a preferential right with respect to payment of dividend and repayment of capital in case of winding up. Well, as far as the share issuance is concerned, it can be a company can issue its share either at par, at premium, or even at a discount. Issue of share at par means a share are issued at par when subscribers are required to pay only the amount equivalent to the nominal or face value of the shares issued, means par value. Is the notional face value of a share which a company issues to its investor. Well, in another case, if maybe suppose company is running for a long time, it is earning profit, and it believes the value that is the face value is not the actual representation or sort of thing. So they can ask for a premium as well. So if the buyer is required to pay more than the face value of the share, then the share is said to be issued at a premium. The premium cannot be treated as profit and therefore cannot be distributed as dividend. The amount of premium received in cash and the equivalent of it received in kind must be kept in a separate bank account known as securities premium account. Well, issue of share at discount. If the buyer of share is required to pay less than face value of the share, then the share is said to be issued or sold at a discount. Share can be issued at a discount if it is authorized by a resolution, that is, the issue is of a class of shares already issued. The maximum rate of discount must not exceed 10%. Not less than 1 year has at the date of issue elapsed since the date on which the company is entitled to commence business, issued within 2 months of the sanction by the company law board, and every prospectus must mention particulars of a discount allowed on the issue of share. Well, issue of sweat equity shares. Sweat equity shares means equity shares issued by the company to the employees or directors at a discount or for consideration other than cash. Sweat equity shares may be issued for providing know-how or making available intellectual property rights, say patents or valuable additions. Well, rights issue. Well, it is section 62 1A. The existing members of the company have a right to be offered shares when the company wants to increase its subscribed capital. Such shares are known as right share. Or when a company, whether private limited company or public limited company, listed or unlisted company, offers its share to the existing shareholders in proportion to their existing shareholding in the company for the purpose of raising fresh capital for the company. Well, in other words, it is a preemptive right that an existing shareholder has in a company in preference to the outsiders. Well, it is a non-dilutive pro rata way to raise capital. It is not mandatory to buy the rights offered. Well, a shareholder can either ignore their rights and let it lapse, or transfer or sell the rights to other interested investor. With these rights, the shareholder of the company can purchase new shares at a discounted rate to the market price. Well, often we see that there is a news in the market. The company is offering shares, and there is a book value date like that. So, company considers a specific date as a book value date. According to on that date, all those who are registered in that company as a shareholders may get the opportunity that is offered by the company. Suppose company declares that it is inviting fresh investment through the shares, and share can be purchased or issued in the specific ratio. Suppose one holding 10 share in the company previously, he can buy 10 more or one more sort of ratio. So the ideal date for that purpose is that book value date, according to date that is fixed by the company well in advance. It is notified on the respective portals. So on that date, all those who are holding a specific share have the right to buy the shares that are offered by the company. At the same time, they have the right that they don't want to invest, they can ignore that offer. Well, then there is a concept of bonus issue. So bonus shares refers to a further issue of shares made by a company having share capital to its existing shareholders without any additional cost. In proportion to their existing holding, bonus shares are fully paid up shares issued to its member out of its free reserves, the securities premium account, or the capital redemption reserve account. No issue of bonus shares shall be made by capitalization reserve created by the revaluation of assets. Well, legal requirements. The bonus shares can be issued only when it is authorized by its article. If not, then amend the article of association, recommended by board of and authorized in general meeting of the company. The company has not defaulted in payment of interest or principal in respect of fixed deposit or debt securities issued by it. Well, payment of statutory dues of the employees, such as contribution to provident fund, gratuity, and bonus, well, then partly paid up shares, if any is outstanding on the date of allotment, are made fully paid up. Well, then there are two concepts with reference to a share. One is called as transfer, another is called as transmission. So transfer is basically transfer of title of shares, to shares voluntarily by one party to another for adequate consideration under the contract. Transfer deed is executed in the transfer of shares and stamp duty is payable on the market value of shares. Liabilities of the transferor cease on the completion of transfer. Whereas transmission is concerned, transmission of title to share by operation of law, that is death, insolvency, or lunacy. It is initiated by legal heir or receiver. On death of a shareholder, his shares are transmitted to his legal representative. When a shareholder becomes insolvent, his shares are transmitted to his official receiver. And on shareholder becoming lunatic, his shares are transmitted to his administrator appointed by the court. Provisions relating to transfer and transmission are slated in the respective sections. When there is a concept of buyback of shares, it's from its own free reserves. Well, a security premium account, the proceeds of any share or any other specified security. However, buyback of any kind of share or security shall not be made out of the proceeds of an earlier issue of the same kind of shares or same kind of other specified securities. Well, there are certain buyback is a concept when company buys back its share from the shareholders. So it may be for various purposes. Well, the buyback must be authorized by the article and approved by a board of directors at a board meeting. Well, approval of board of directors up to 10% of total paid up equity capital and free reserves of the company. Approval of shareholders required if up to 25% of aggregate of the paid up capital and free reserves of the company. Share to be bought back must be fully paid up. The buyback of share of private and listed companies may be from the existing shareholders on a proportionate basis by purchasing the securities issued to employees of the company pursuant to a scheme of a stock option or a sweat equity. Well, before the buyback of shares, the company shall file with the registrar of companies a letter of offer. and the offer of buyback shall remain open for a minimum period of 15 days, but not more than 30 days from the date of dispatch of letter of offer. Well, buyback shall be completed within a period of 1 year from the date of passing of a special resolution or board resolution in that as the case may be. Well, the ratio of aggregate of secured and unsecured debt owed by a company after buyback shall not be more than twice the paid up capital and its free reserves. Well, then there is a concept of surrender and forfeiture of shares as well. Well, surrender implies giving the shares back to the company either by a settlement of a dispute or for any other reason. The Companies Act contains no provision for surrender of shares. Thus, surrender of share is valid only when Article of Association provides for the same and where forfeiture of such share is justified or when shares are surrendered in exchange of new shares of same nominal value. Well, then there is a concept of forfeiture of the share as well. Well, if a shareholder fails to call on shares, the company has following options to sue him for amount due and forfeit the shares, that take away the shares forcefully. Well, the company may, if expressly authorized by its articles, forfeit shares for non-payment of calls, and same will not require confirmation by the tribunal. Where power is given in the articles, it must be exercised strictly in accordance with the regulation regarding notice, procedure, and manner stated therein. Otherwise, the forfeiture will be void. Well, then there is another mechanism, that is debentures. Debenture is the most common form of raising loan from the public by a company. Well, it is defined as Section 2, subsection 30. It includes debenture stock, bonds, and any other instrument of a company evidencing a debt, whether constituting a charge on the asset of the company or not. When debentures are issued, the applicants are given certificates and its common seal, if any, or under the signature of two directors or a director and a company secretary, if he has been appointed representing the company, representing money they have lent to the company. When there is another mechanism of raising fund, that is deposits. So company can raise fund through this way as well, and from various aspects, and sort of interest is promised or return is promised to the investors in this. Then there is an interesting aspect about the company, that is the concept of management. So the company, as you understand, is an artificial person. Its affairs are to be managed by a natural person, obviously. Well, the management of corporation is a collective responsibility. Thus, to who manage the corporation known as various names such as director, managing director, secretaries, etc. And the board of directors is a group of people elected by the company's shareholder to represent their interest. The board acts as a GV and for a company, for corporation. The board of director is carrying out the day-to-day affairs of the company, has to perform the role within the powers which are granted to them. Certain powers can be exercised by the board on their own, and some with the consent of the company at the general meeting. The shareholders are owners of the company, ratify the actions of the board at the general meeting of the company. The meeting of the shareholders serves as a focal point for the shareholders to converge and give their decisions on the actions taken by the directors. And at times, these meetings give the direction for the future course of action as well. Well, board constitution and its power. The board of directors is selected according to the procedure prescribed in the Companies Act 2013 and the article of association of the company. All public companies are required to have a board of directors that includes members from inside as well as outside of the organization. Well, Section 2, subsection 10 of the Companies Act defines the board of directors. Board as a collective body of directors of the company. Thus, the term board of directors means body duly constituted to direct, control, and supervise the affairs of the company. Well, the BOD, board of directors, is the trustee of the company. They are responsible to act in the best interest of the company and oversee that the management serves and protects the long-term interest of all the stakeholders of the company. They do this by meeting regularly to create policies for overall company oversight and management. Well, the minutes of board meeting and general meeting and the reports of various committees are recorded and documented as the acts of the company. Well, as far as the composition of the board is concerned, It has got a company can appoint maximum 15 directors, but this can be increased after passing a special resolution in general meeting. Well, Section 8 companies can have more than 15 directors even without passing a special resolution. Then there are a specific number of directors, like board must be having three directors in case of public company, two directors in case of private company, and one director in case of one person company. Well, every company to have at least one resident director who must have stayed in India for a total period of not less than 82 days during the financial year. One woman director. At least one third of the total number of directors are independent directors. Fraction is to be rounded off to one. Well, Regulation 17 of SEBI, that is LODR Regulation 2018, further elaborates the composition of board of directors of a listed company. Well, then there are certain powers that are vested in the board. Well, they can borrow money, invest fund, they can grant loan, etc. They can approve financial statement to diversify the business, to approve amalgamation, and to appoint internal auditor, to invite or accept or renew public deposits and related matters. Then there is restriction on the powers of the board as well. They cannot to sell, lease, or dispose of whole or substantially the whole of the undertaking of the company. They need a special consent is also required for all those purposes. Basically, it is to look for the safeguard of the company. So, if they are doing something in the best interest of the company, that is to be defined or identified as well. Then there is a component that is director. So, a person who are the persons who are in charge of the management of the affairs of the company are termed as directors. They are collectively known as board of directors, as we explored earlier. And their maximum and minimum numbers are mentioned. Well, the qualification or quality of a director should be he is of are defined well in the act, but the disqualification a person can be or shall not be eligible for appointment includes he is of unsound mind, undercharged, insolvent, pending application to be adjudicated as insolvent, convicted for moral turpitude, foreign exchange regulation, bears imprisonment for more for not less than 6 months and 5 years are yet to be elapsed from the date of expiry of the sentence. If a person is convicted of any offence and sentenced with respect thereof to the imprisonment of 7 years or more, he shall not be eligible to be appointed as a director in any company. A court or tribunal has passed an order disqualifying him for appointment as director and the order is enforced. Well, shares held by him are in arrears for more than 6 months. Well, accepts directorships exceeding the maximum number of directorships permissible. Well, if the court refrains for committing fraud, such as when the director of the public company not file financial statements or annual returns for any continuous period of 3 financial years, fail to repay the deposits or pay interest thereon, or to redeem any debentures or the due date or pay interest due thereon, or pay any dividend declared, and such failure to pay or redeem continuous for 1 year or more, and the 5 year has not elapsed. Well, as far as the director and their appointment is concerned, it depends upon the appointment of first director, that is defined in section 152(1), and the appointment of first director in section 152(2) is clearly mentioned. Then there is a concept of woman director also. Specifically, every listed company and every other publicly limited company with a paid up capital of 100 crores or more, or with turnover of 300 crores or more, must have at least one woman director. Every existing company was required to appoint a woman director within 1 year from the commencement of the act, and every newly incorporated company shall appoint a woman director within 6 months. Then there is a concept of independent director. An independent director means a director other than a managing director, whole-time director, or a nominee director who does not have any material or pecuniary relationship with the company directors. Certain companies that have been specified under the independent directors, all the listed public company would have at least 1/3 of the total number of directors as independent directors. Fraction is to be rounded off to 1. Other public companies with paid up capital of rupees 10 crore or more, with turnover of rupees 100 crore or more, or with outstanding loans debenture deposit of rupees 550 crore or more to have at least two independent directors. An independent director can be appointed for a term of up to 5 consecutive years on the board. However, in case of his reappointment for further 5 years, then a special resolution is to be passed in general meeting and disclosure of such appointment is made in the board report. Then there is alternate director. Whether in public or public private company, a board can appoint alternate director provided it is authorized by its article or by resolution passed by the company. Additional directors, small shareholder directors, well, appointment of director by tribunal, and then there may be vacation of the office of director due to if he incurs any of the disqualification, he absent himself from all the meetings of the board of directors held during the period of 12 months day to date, with or without seeking leave of absence by the court. He acts in contravention of the provisions relating to the entering into the contracts. He becomes disqualified. He convicted by the court of an offense, whether moral, tripartite, or otherwise, and then consideration and are the object. And the object are some of the essentials of valid contract. He becomes disqualified. He convicted by the court of an offense, whether moral. As far as the consideration is concerned, it follow the doctrine of estopel or quasi estopel and utilize the rule of penal's case. Then one should be in the capacity to have a contract. As far as the consideration is concerned, mutuality of mind, the parties to contract must have a consensus, which means mutuality of mind as to subject whether consideration is concerned. The lack of mutuality of mind makes the contract void. Free consent, the consent of the party to the contract is said to be free if it is not caused by coercion, undue influence, fraud, misrepresentation, and mistake. These are further explored and explained as well. If it is not caused by legality of consideration of an object, apart from the above certain essential formation of various contract, legality of the constitution object is must, and the unlawful agreements may be classified as illegal where the agreement is contrary to the statute or immoral, opposed to the public policy, and they are not unlawful agreements may be classified. And performance of contracts, well, both the parties to the contract either perform or offer to perform their respective promises until such performance is dispensed with the excused with or excused under any provision of this act or any other law enforced. Even the death of one of the party makes his legal representative liable unless the intention of the parties to the contract any provision of this act. Well, time and place of performance is concerned when the promiser has to perform without the application of promisee and no time is specified in the contract to perform, the performance must be done within reasonable time. And as far as the reasonable time is concerned, when the time is specified but no application to be made by the promisee, the promiser may perform at any time during the usual hours of business or such day and the place at which the promisee ought to be performed. It is the duty of the promisee to make the application of performance on certain date to be at proper time and place during the usual hours. And the place, as far as the proper time and place is concerned, it is the duty of the promiser to make an application to the promisee as to the time and place to perform. When the promise is to be performed without application, the promisee may prescribed or sanctioned the manner, the time, and place of the promisee as to the time and place to perform. Well, doctrine of frustration or agreement to do an impossible act. Well, the agreement between two parties to an impossible act is itself as void. Well, a contract may also be void because of an event which makes the performance of promise impossible or even unlawful after the completion of the contract. Any person who makes promise to perform by knowing it to be impossible or unlawful is liable to pay compensation to the promisee that is not aware of the impossibility of or unlawful nature of the contract right to be impossible or unlawful is liable. Well, supervening impossibility, the very object of this subject matter relating to the contract disappears. The contract is discharged by frustration on the ground of destruction of subject matter. A contract is also considered as frustrated in case of non-occurrence of expected events. The musician who failed to perform a concert due to illness, as agreed in theatre, was held the frustrated and is also discharged as successful in case of non-occurrence of expected events. The musician who failed to perform a concert due to illness, as agreed in theatre, was held the frustrated and is also discharged as successful in case of non-occurrence of expected events. The musician who failed to perform a concert due to illness, as agreed in theatre, was held the frustrated and is also discharged as successful in case of non-occurrence of expected events. The musician who failed to perform a concert due to illness, as agreed in theatre, was held the frustrated and is also discharged as successful in case of non-occurrence of outstanding as suggested by the debtor, the contracts which need to be performed. The original contracts between the parties need not be performed in case of novation, rescission, and alteration of such contract. If the parties agree to substitute a new contract instead of original one, or to rescind or to make alteration in the contract, the parties of the original contract of such obligations therein as well. The promise is at liberty to promisee at the liberty to dispense with performance of the promiser wholly or partly, or extend the time of performance, or may also accept instead of it any satisfaction which he deems just. When a person having the option of rescinding the voidable contract exercises his option to rescind, the other party need not perform his part or promise in the contract. Well, there are certain examples of quasi contract. Action for money had and received. Money paid to plaintiff for use of defendant. Quantum merit. Obligation of finder of lost goods. Necessary fees supplied to a person incapable of contracting. And then there are certification of consequences of breach of lost goods. Well, one is common law of remedy, which is for remedies, for damages, and then equitable remedies. As far as common law remedy is concerned, that is damages, the remedy of damages there only tries to evaluate in terms of money the loss which a party sustained as a result of breach of contract. As far as equitable remedy is concerned, well, that is a specific performance of contract, injunction, rectification, and cancellation, etc. Keeping in mind that a specific performance is not available in every case, subject to several limitations, there is no other alternative for courts than to award damages, which of course is available in every case. Well, the measures of damage is the value of performance that of contract to the plaintiff, and not what it cost the defendant to perform it. There are four kinds of damages: one, general, ordinary, or substantial damages; special damages, vindicative or punitive or exemplary damages; and nominal damages. Then they are further elaborated individually as well. Uh, with this, let's move to the next unit, that is international contract of sale. Uh, there may be possibility of transaction between the parties arising of two different states or countries. With the introduction of LPG, that is that we call in a very simple terms, but it is liberalization, globalization in the marketing term. It wiped out the boundaries among countries and made the world as a global village. The transactions of sale at the international level are considered to be the backbone of international trade through international contracts. The contracts are regarded as international contracts when the parties to the contract are coming from two different states. Well, in 20th century, basically 20th century focuses on uniform framework to tackle the situation of diversified legal system. Before Second World War, Ernest Rebel suggested the possibility of uniform sales law to the Institute for the Harmonization of Private Law. In 1930, Unidroit initiated the project to prepare a law unifying the substantive rules governing international sales contracts under the auspices of League of Nations. In 1964, two conventions, namely Uniform Law on the International Sale of Goods, that is ULIS, and Uniform Law on the Formation of Contracts, ULF, unifying the law of international sale of goods, were adopted and came into force in 1972. These are still not widely recognized outside Western Europe as instruments of international harmonization. Well, finally, draft of the conventions of the international sale of goods, that is CISG, approved in the General Assembly in June 1980 and came into operation on 1st January 1988. Well, CISG is now supported by a number of conventions like UN Convention on the Limitation Period in the International Sale of Goods, the 1983 Geneva Convention on the Agency in the International Sale of Goods in 2005, Convention on the Use of Electronic Communication in International Contracts in 1983, Uniform Rule on Contract Laws for an agreed sum due upon failure of performance. And so far, 94 countries ratified and acceded to the convention as on 2020. Well, applicability of law and rules. Conventions in some international sale contracts, the law applicable to a contract will be provided for in a treaty. The UN Commission on the International Trade Law, that is UNCTRAL, has created three treaties that provide the applicable rules governing certain contracts. One is United Nations Convention on the Contracts for the International Sale of Goods (ESG), the Convention on the Limitation Period in the International Sale of Goods, the United Nations Convention on the Use of Electronic Communication Convention in the International Contracts, the United Nations Convention on the Use of Electronic Communication in International Contracts 13. In 30 contracts is a much more recent treaty than the CISG or Limitation Convention adopted in 2005. It has currently seven state parties. Well, then national laws. Parties may also choose national laws to apply to their international commercial contracts. The party with greater bargaining power may insist on its national law, or parties may insist choose the law of third state, usually one considered to have a well-developed law with regard to commercial transactions. English law is frequently used in international transactions, in particular with reference to reinsurance, charter treaty, sea trade, among other areas. Parties may select Swiss law because of the perception that Switzerland's political neutrality makes this a neutral law. Nonetheless, political neutrality may not always be the best guide as to the suitability of a chosen law for a specific transaction. Well, the ICC International Court of Arbitration 2013 statistical report mirrors the survey and also indicates frequent choices of German and French law. When considering these type of surveys, it is important to recall that generally the choice of law of any CISG state will also include a CISG unless the convention's application is clearly excluded by the parties. Soft law and trade uses. There are many international texts and standards that may be chosen by traders to govern their contracts. These rules may be transferred to variably by rules of law, soft law, or trade uses, but they are connected by their use in international contracting and potential direct application by arbitral tribunals. The unit right principles of international commercial contract were first finalized by Unit Right in 1994, revised in 2004 and 2010. It continues to revise the principles as appropriate, currently considering revisions meant to deal with the specific aspects of long-term contracts. CISG's approach in many instances are a set of general rules. We can consider them a set of general rules for international commercial edition. They are able to cover areas that the drafters of the CISGs were not able to agree upon, such as validity, agency, and assignment, among others. Let's explore. The Lex Mercatoria has been described as a synthesis of generally held and generally accepted commercial principles that may be expected to be applied to contracts among the major trading nations. There is a controversy surrounding the Lex Market area, and in particular, they specifies of its content, but arbitrary travels can nonetheless were authorized to apply these principles. For example, of a contract clause containing choice of such broad principles consider the United Nations General Conditions of Contract, which state with regard to dispute settlement that the decisions of the arbitral tribunal shall be based on general principles of international commercial law. Well, Incoterms, in the specific area of delivery of goods, International Chamber of Commerce (ICC) has developed a set of rules governing trade terms that describe the obligations of buyers and sellers and supplements any other rules governing the contract. The terms are in combination of three letters. One example is FOB, standing for free on board, and the Incoterms rules cover who bears the risk and obligation when the seller has contracted to deliver the goods. In this way, namely, on board the vessel nominated by the buyer at the named port of the shipment or procures the goods already so delivered. Uh, the Uniform Customs and Practice for Documentary Creditors (UCP 600). This was another creation of International Chamber of Commerce for the convenience of international trade. The Uniform Customs and Practice for Documentary Credit 2007 revision UCP 600 is the soft law instrument for the regulating letters of credit as a common payment method in international transactions. The contract must indicate the entity's application of UCP 600 towards the credit document. It contains rules specifically for electronic records. Well, as far as the model contracts and clauses are concerned, contracts can cover all aspects of international trade, although the most commonly used are international sale contract, international distribution contract, international agency contract, international sales representative contract, international supply contract, manufacturing service, strategic alliance, joint, and franchise contract. As far as the assessment of sale of goods by transfer of property with certainty and flexibility is concerned, the transfer of property takes place when the contract is concluded, even the delivery and payment of price happens subsequently. This principle was adopted by French law by Code Civil in 1804. The same appears in English rules set out in the Sale of Goods Act SOGA 1893. The other system of transfer of property is stipulated by the delivery, which was seen in general law and Australian law, and formal talks of abstract delivery, and the later with the casual delivery as well. Well, there are certain regional efforts as well. The preamble of CSG states that the adoption of uniform rules which govern contracts for the international sale of the goods and take into account the different social, economic, and legal systems would contribute to the removal of legal barriers in the international trade and promote the development of international trade. The European Commission proposed a new uniform law on the sale of goods intending to solve the problems arising from this diversity of national contract laws. The Common European Sales Law (CESL) governs sales to both consumer and business. The CESL would then offer a new choice between the legal system, and the parties can make freely any national law, either of EU members or other states as well. Well, according to Secretariat, the system would collect, analyze, and monitor national case law related to UNCITRAL text, report the findings to UNCITRAL, and address the need of the judiciary to better understand the internationally prevailing application and interpretation of neutral standards and achieve effective cross-border cooperation. Resources are the biggest obstacle to such a proposal, as noted in the by Secretariat. Well, during the operation or functional operation of various contracts that were set up in the pre-COVID-19 scenario, created certain problems. What many of the players could not complete their contracts due to n number of reasons during the COVID-19 pandemic, because during the pandemic, each country performed differently. So, uh, uh, the CISG Article 79 provides that a party is not liable for a failure to perform any of his obligations if he proves that the failure was due to an impediment beyond his control, that he could not reasonably be expected to have taken impediment into account at the time of conclusion of the contract, or to have avoided or overcome it or its consequences. So this help in many ways in resolving many issues. But at the same time, from the local level, government levels, the packages that were offered by the government to restore the normalcies, because there was some many of the problems that was unexpected. So ICC in 2020 changed hardship clause, which suggests three different legal consequences in the event of failed renegotiations, any of which the parties can choose when concluding the contract: the termination of contract by one of the parties, the termination of contract by a judge or arbitrator, or finally the adjustment or termination of the contract by a judge or arbitrator. Well, with this, let's move to the next unit, try to cover it. So far, we talk about type of business, structure of business, and the contracts, national, international contracts. We touch upon an aspect of finance also, equity also. So, to address the concept of finance, or to favor the concept, support the industry with the funding, there is a concept of bank that we see surrounding us. But this concept of bank evolved over the period of time, and itself it has got a very big industry. So in this unit, we will explore exploring what is the bank exactly. So in simple terms, we can say bank is an institution which collects money uh, from the investors and redistribute this money to the borrowers, and earns profit. From this profit that bank earns, it runs its operation, as well as it gives money to the, or it gives part of the profit to the investor as well. So to general discussion, it seems to be a very simple process. But the complication is the bank receives money of the investor in the manner of a trust. But if a borrower fails to repay that back, so how the bank is going to return to the investor? So the element of safeguarding the rights of investors is very important, so that bank is not failed. That is one component. At the same time, everything cannot be left upon with the management of the bank to ensure that it is looking after the safeguarding the investments. The state should play some role as well in ensuring the safeguarding of the investors' money also. So for that purpose, there must be some regulator or player in that regard. So for that purpose, in Indian context, there must be a central bank or a government bank that we can say RBI, so which forms the policies and regulations with reference to management and operation. We will be exploring this particular unit in detail in the coming section, because it's a very interesting one, specifically with reference to banking. So with this, I wish to conclude today's section. Namaskar.